although it was originally my idea to test the question of whether the Scottish Parliament had the competence to hold an advisory referendum, I've not been involved in the legal advice in this case. The case is led by the Lord Advocate on behalf of the Scottish Government, as is proper, but the SNP have also made an intervention in the case, and it is fair to say that I've discussed the terms of that intervention with the First Minister.
And you're in the you're in the optimistic camp on this, cautiously optimistic, saying that you think we might get this passed.
Yeah, I'm cautiously optimistic. I mean, I think Professor Aileen McHarg, who of course is an academic and an independent observer, she's pointed out that the outcome of constitutional cases is rarely very predictable. And I know that from my own experience, because I led the case about the unlawful prorogation in Scotland. Of course, the chattering classes, both north and south of the border, all said we'd lose that case. In the end, we run it flat out, unanimously, both in Scotland and in the building behind me. So I'm cautiously optimistic. And what I'm hoping is that the UK Supreme Court will look not just at the interpretation of the 1998 Scotland Act in very black letter law terms, but they'll also look at it in the wider constitutional context. Scotland's right to self-determination, which is well established under international law, respect for the Scottish Government's mandate obtained at the last general election, and principle of democracy, which I was taught when I was at law school is central to the British Constitution.
Do you take any position on the sort of maybe contradictions in the SNP's submissions to the Supreme Court versus that of the Lord Advocate? Lord Advocate kind of saying, essentially, allow us this because it's a glorified sort of opinion poll. The SNP say this is fundamental to the human rights of the people of Scotland. Do you see a kind of contradiction in those positions?
I don't think they're contradictory. I think they are complementary. The Lord Advocate has set out in her written submission the case for and against the interpretation of the 1998 Scotland Act, which is central to this case, and she'll put the case for this morning. The SNP's written submission complements that by stressing the sort of principles I was talking about a minute ago, the principles, the right to self-determination in international law, respect for government's mandates, and the principle of democracy, which, as I say, should be central to the British Constitution. It's also worth noting that in an interesting article written by a couple of legal academics last week, they agreed with me that even if the Supreme Court finds against the Scottish Government's submission, the Supreme Court really ought to make some wider comments about the constitutional context of this case, about how regrettable it is in terms of the British Constitution that the British Government is ignoring the democratic mandate of the Scottish Government.